All right, I do have the AG here as well. So Mr. Berkey, I do have Mr. Brown and Miss Underwood. So we can start with that one. That way you can move on your way.
Morning, Arnold. Thank you.
Judge, for Mr. Brown, I did submit a letter for you. Since that time, payment has been made, so I'll give an update when you're ready.
Okay. Davis, Hodges. Miss Adams, do you have Brandon Brown back there?
I will look.
I don't have it here. I have Davis, Evans, Goncalves, Hodges, Marvin, Rembert, Sinclair, Coaster, Daniels. I have the PS. So. And I don't, I'll step up under for just a minute. They're good. All right, thank you. Mr. Brown, go ahead and unmute your device. So this is in the matter of the people of the state of Michigan versus Brandon Brown. File number 24-21679FH. I have Ron Underwood appearing on behalf of Mr. Brown. I have Mark Berkey, right?
It's actually Burke, but I go by Berkey also. I get it every single day.
I'll go with Burke. I couldn't remember for some reason. Appearing on behalf of the Attorney General. And I have Darren Coast from Pretrial Services. So, Mr. Coast, I did have a letter from August 20th, 25. At that time, you stated he has not made any progress and he owes $6,000 on 2018-45880 DP. Thank you. And $15,566 on docket 2009-34792 DP. And now we have an active warrant for his arrest out of Belleville, Michigan for not paying on a third child. And on that case, he owes $11,534.44. So, Mr. Coast, at the last review, we had advised Mr. Brown to get a job and supply proof. So you do have an update today then, Mr. Coast?
I do, Judge. I've been talking to Mr. Brown. He did supply me some proof that he's going through a staffing agency called Drive, that he does have a job lined up with Martin Rhea. He told me he was supposed to start this week, but apparently it was pushed to a later date. I believe he told me August 21st is his start date. I also asked him to provide me with some receipts of the payment, which he did do. He did make payments, $350 on each case, so a total of $700, and that was done yesterday. And he did provide me with those Lenawee County front of the court receipts.
Okay. Is that a felony warrant out of the other court or county? Or is it just a show cause warrant?
I'm not sure, Judge. I did check with the friend of the court downstairs, and they advised that there was an active warrant. They didn't state that it was a felony or a misdemeanor.
All right, Mr. Burke, any update on that?
I'm not aware of another warrant that this defendant has, at least not through our office. But I did look at the note from the sentencing that was scheduled for July, that was conducted on July 18th. And yeah, I think what Your Honor indicated was correct. But and then I looked at my MISIS report, which is the report that shows payments and credits, things like that. And my number as of 8/20, which was 2 days ago, was $6,862.54. Now it sounds like the defendant made a $350 payment yesterday on this case, which is good. But obviously that's, there's not a whole lot, beyond that. So the last payment before that was in May of 2025, and the amount paid to this docket was $161.56. So that's the information that I have. He still has an ongoing supply relation of $333 a month in this case.
Now, Ms. Underwood, I can tell you're itching to update me, so go ahead.
In addition, Your Honor, Mr. Brown has submitted income withholding documents that will take out an additional $50 out of each paycheck for each arrearage, Your Honor. He wants to get this arrearage going down. Mr. Brown is eager to have that happen, and we believe this is the start of that, Your Honor. He has addressed the arrearage with the income withholding, and I think everything that Mr. Brown has done, it may be late, Your Honor, but it's very positive, and we would ask for an adjournment.
So, Mr. Brown, one thing you need to understand is you're not going to be able to make enough money to pay all your child support payments and your payments on your arrearages without getting a second job. Do you understand that? Because you have 3 cases you have to pay on. You got 1 in warrant status. So if you haven't already, you need to make a payment on that and contact that friend of the court to get that warrant quashed, because if they pick you up, you're going to lose your job at Martin Rhea. Do you understand that?
Yes, Your Honor.
And
I am looking for a second job currently. So I did start. I already started at Martin Rhea. So I'm not waiting to start. I had one position and they switched me positions. So I worked like 4 or 5 days and then I go back Sunday night again. So then I'm full time.
So the next thing you need to understand is when you get your first paycheck, you need to look at it, because there's a good chance the income withholding won't be in place yet. So if they have not deducted child support, you need to make every payment until it starts coming out. And then even when it starts coming out, you got to add up all your cases and make sure you make a payment on each case and additional on the arrearages, at least on my files. All right.
Yes, Your Honor.
And, it takes, 5 minutes to make a baby, but it takes 20 years to support them. So, you're running out of time, Mr. Brown, and you're going to end up either in jail or prison. Do you understand that?
Yes, Your Honor.
All right. Ms. Underwood, I will give you one more adjournment on this. So I'm going to set this. What's your shift at Martin Rhea?
I'm on 3rd shift, ma'am.
And so you're going to work at what time?
10 to 6.
10 to 6. All right. So Miss Adams, I would like to set this for like December 18th or 19th in person.
Okay. Yes, we could do December 19th.
I'm going to do it at 8 a.m. because I know you need to get to work, and that's going to be in person. So Mr. Brown, I would highly advise that you've been making payments and doing everything you're supposed to be doing when we come on that day. All right.
Got it.
All right. So we'll see you back December 19th at 8 a.m. in person. Thank you, Mr. Burke.
Thank you.
Oh,
Adam.
yes.
Just two questions. First of all, is that a sentencing or is that a review?
A review.
A review, okay, all right. And then, do you want the Attorney General's office there in person?
Say it again.
Would you like the Attorney General's office to appear in person or are we okay by Zoom?
You're fine by Zoom.
All right, perfect. Thank you, Your Honor. Appreciate that.
Okay,
Thank you,
Your
Ms.
Honor.
Underwood.
Mr. Burke.
I
Thank
got
you.
one.
Have a great day.
Me too. Mr. Brown, you want to say something to Ms. Underwood?
No, I just got a question for the court. So, Belleville, I have a court date later this month. So is that a bench warrant or is that just active, or is that a felony warrant? Or nobody knows?
I think that it's a friend of the court show cause warrant,
Right,
which
right.
probably if you make a good payment or talk to your caseworker there, they might quash.
Okay, that's the problem with Wayne County. You can't get through to anybody. So, but okay, I will take care of that too as well.
Okay, thank you. Sometimes you just show up with money and that helps. All right. Okay,
Thank you very much, Your Honor.
Sure.
Have a great weekend.
thank you, Mr. Burke.
Thank you,
All
Ms.
right.
Underwood.
Thank you, Mark.
Thank you. Good to see you.
All right, Mr. Rains. Zachary Davis, you said, Mr. Rains?
Yes, Your Honor.
All right, Ms. Underwood and Mr. Malaro, I'll be right with you in a minute. All right, if you could stand at the podium. All right, do you have an advice of rights for your client?
I do.
Okay, I got you one up here. There'll be a sheet that says advice of rights. Yep, give it to Mr. Rains. Court rules changed. We have to do those now, and so. Yep, just bring it back to me. And then, Mr. Davis, I'm gonna go through the rights. We just have to have it in written form. Thank you. All right, this is in the matter of the people of the state of Michigan versus Zachary Allen Davis. We have two files, 24-22014FH and 24-22015FH. I have Lowry Rains appearing on behalf of Mr. Davis, and I have Dave McCready appearing on behalf of the people. I have received back a signed copy of the advice of rights, and I have received a plea agreement form that was signed by Mr. McCready. And I don't, Mr. Rains, do you have a copy that you guys? Oh, look at.
Yes, Your Honor.
Yeah. Do you want a copy back that's not signed for reference?
If I may, thank you.
Okay, there you go. All right, so now I have a copy of the plea agreement that's been signed by all parties. As stated in this plea agreement, the defendant agrees to plead guilty to count 4 on file number 24-22015FH. That is an added count. And do I have an amended information?
You should. I have an extra copy.
No, it might be in my file. It might be in my file. It's not, but
We filed it last night or yesterday afternoon sometime.
that doesn't mean anything. It's got to go through the clerk's office and sometimes. But now I have,
Could you tell me the first name? I don't see this on the docket.
it's not on the docket, so it's Zachary Allen Davis.
You can tell her I got it.
Oh.
I write it down.
Miss
thank
Holly
you,
has
Joanne.
it.
Thank you.
Okay, so the plea agreement is that he will plead on file number 24-22015FH to the added count 4 weapons, firearms, reckless use. That is a 90-day misdemeanor and or a $500 fine. So this is a misdemeanor plea, so doesn't even need you anyway, Miss Walsh and Miss Holly. So the court may suspend hunting privileges for up to 3 years. Count 1, felonious assault, count 2, felony firearm, and count 3, domestic violence will be dismissed at the time of sentencing. And there will be 2 years probation with no upfront jail. And while on probation, defendant will comply with the attached probation conditions. Okay. I've never seen that before, but as a term of probation, there'll be no consumption or possession of alcohol. Report to probation as recommended by the probation officer, drug and alcohol testing as determined, attend a 12-step meeting as recommended by the probation officer, attend individual counseling as recommended by the probation officer, conform to curfew if any is established by the court, no possession of firearms of any kind, including at home or in vehicles, home or vehicles subject to random inspection for alcohol and firearm, no contact with Brianna Davis other for parenting time issues. Those are standard terms that would have been issued anyway, but we don't typically do that. So I appreciate it though. And there's no other agreement regarding fines and costs or anything else. And all other charges on this file would be dismissed and the other file would be dismissed as well.
Correct.
All right. So Mr. McCready, is that a correct recitation of the plea?
Yes, it is.
And Mr. Raines?
Your Honor, it is an accurate recitation of the plea. However, my understanding is there is one other additional part of this plea. Mr. Davis has been strapped with a scram unit for the last approximate year as a bond condition. My understanding is at the time that he enters this plea, that the prosecution is agreeable to him being released from that tether device.
That's correct. It's not technically part of the plea, but once the plea is entered, I have no problem with him being released from it.
All right. And did you report to Darren Coast?
Yeah.
Okay.
I've spoken with Mr. Coast and he's indicated that there's been only one violation while he's been on the unit. It's back in 2024. So.
Okay. All right. Anything else, Mr. Raines or Mr. McCready?
No, Your Honor. I think that accurately now states in terms of the figure.
Okay, scoot over by your attorney a little bit because I need you by the microphone.
Yep.
Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you're going to need to speak up much louder so that because we are recording it and so it needs to be able to be recorded, okay?
Yep.
So repeat your response.
Yes, I do.
All right, and state your full name for the record, please.
Zachary Allen Davis.
All right, so Mr. Davis, I know we gave you a copy of the advice rights and you signed it and returned it. I'm going to go through those same rights with you now and even expand on some of them, okay? So, sir, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count for weapons, firearms, reckless use on file number 24-22015FH?
Yes.
All right. Are you satisfied with Mr. Raines as your attorney and the advice that he has given you?
Yes.
Do you understand the maximum penalty for this offense could be up to 90 days in jail and or a $500 fine?
Yes.
And that the court, if it so chooses, can suspend your hunting privileges for up to 3 years?
Yes.
And the people have not spoken on that, correct?
Correct.
Okay. And neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court other than the plea agreement. Is that correct, Mr. Raines?
Other than what's contained in the plea agreement and those probation conditions that you've already gone over on the record. That's correct, Your Honor.
Mr. McCready?
That's also correct. Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Okay, so basically what that means is, if you had been convicted at trial, you have an automatic right to an appeal.
Okay.
But if you enter a plea, you don't, and you have to file for leave to appeal. So you have to ask them to hear your case. Does that make more sense?
Yeah.
Okay. Do you understand, and this is a change in the law, do you understand that if your plea is accepted and you engage in any misconduct as defined under MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right, Mr. Davis, how do you wish to plead to the charge that on or about July 15 of 2024 in Raisin Township in the county of Lenawee, that you did commit the offense of weapons, firearms, or reckless use? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I understand.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Raines?
No.
Mr. McCready?
No.
Has your attorney promised you any other particular sentence or estimate what your sentence will be in terms of any other terms of probation or fines and costs? Other than the agreement that you agreed to?
Yeah, no.
Okay. And is it your own choice to plead guilty?
Yeah.
All right. So, Mr. Davis, on July 15 of 2024, were you in Raisin Township in the county of Lenawee?
Yes.
And at that time, did you have a SIG 9mm on you?
Yes.
All right. And were you reckless or heedless or want in some way discharge that weapon?
Yeah.
Okay. And Mr. McCready, any follow-up on that?
You would agree that that was an unreasonably unsafe thing to do, to fire that weapon in your home?
Yeah.
And unsafe?
Yeah.
Okay. All right. Are you satisfied, Mr.
Yes.
McCready? All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Raines?
The court has complied.
Mr. McCready?
Yes.
All right. I accept that plea has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation department for a pre-sentence investigation. Miss Adams, could I get a date for sentencing, please?
Judge, that would be October 3rd at 8:15.
Could I get a notice of hearing from Mr. Davis?
Sure.
All right, so. Okay. So October 3rd at 8:15 in the morning, we're gonna get you and your client a notice of hearing, Mr. Raines. And Mr. McCready, are you asking in person or can it be via Zoom?
Via Zoom is fine.
Mr. Raines?
Yes, please, Your Honor.
And now you do have a right to appear here in person for sentencing. But if you choose to do Zoom, you can. What would you prefer?
Zoom. I'm
Okay,
an hour away.
okay. Well, Mr. Raines, they won't be able to speak with him this morning in district court. So let's see, today, I don't even know where I'm at. Today's the 22nd. So on August 28th, he's going to have to appear at the district court probation department between 8 and 10. Because it'll take us time to process the file to get it down to district court. When you meet with them, sir, you need to be truthful about your background, the events that occurred. They'll prepare a pre-sentence report. They'll get a copy of the proposed probation terms. Understand that the court is in no way limited to those probation terms, and the court can give any probation terms above and beyond that if they so choose. Do you understand that? Okay. So even though they're proposing probation terms, the court has final authority on what your probation terms are. So I could exceed it. Do you understand? I could do more things, like require more classes or community service and stuff like that.
Even though I already did them all?
You're going to be on probation for a period of time.
Okay.
So I may order, other things, and I'm not limited to what the prosecutor wants you to do. Do you understand that? Okay.
Yes.
All right, thank you. So we will see you back via Zoom that day, Mr. Raines. Typically, we get the pre-sentence report. I think you guys get it directly from probation, but we send it to the defense attorney, and then you'll be able to review that with them before sentencing. All right, have a seat.
Was he to report to district court today or
No.
just on the 28th?
So the 28th, because, and I will change the bond to allow his tether to be removed. And, but sir, oh wait, I got Darren Post now. Understand that if you violate any of your conditions or have contact or go where you're not supposed to go, I can remand you to custody.
Yeah, I'm not gonna.
Okay, Mr. Coast, I have Mr. Davis here, and he's entered a plea, and part of the agreement was he could have his GPS tether removed. Do you want to
Very
talk
good,
to him in the
Judge.
hall?
Okay. Yep. He did really well in counseling and completed both their programs, and he's been staying away from the alcohol. So Zach, with that, you could go ahead and return your device. I'll alert JSG of that.
All right.
Okay, excellent. Thank you.
Thank you,
And
Judge.
make sure all your certifications or documents regarding the programs you've completed, you bring a copy for the probation department when you meet with them.
I don't have one for Sally, but
She'll get you one.
okay.
Okay.
Hey, Zach,
Thank
Zach,
you.
I actually have that. I'll get you a copy. I'll meet you in the hallway.
All right.
All right. Thank you. Thank you. All right, Miss, oh, there she is. Do you have another one this morning?
Mr. Evans, we're already on that, I believe.
You ready on that one, Mr.?
Yeah, I guess.
Maybe not? Okay. All right, Rhonda is Matthew Sinclair's in jail, isn't he?
He is, Your Honor.
All right.
I just chatted to Ms. Adams.
Did she chat back?
Not yet.
She doesn't chat back with me either. She ignores me.
I'll send it now, Rhonda.
Thank you.
Do you have any tattoos? Yeah. Somebody? Yeah, it hurts a lot. So my daughter and I have matching ones. Got matching ones. It was worse than childbirth. Is that the only thing you had, Ms. Underwood?
I believe it is, Your Honor, unless there's another pickup.
No. All right, so.
Your Honor, did you get a copy of the fresh notations that Mr. McCarron has made?
Yes, I have an email from this morning.
Okay.
From Sally Welsh. I can't get the jail. They're not taking my calls this morning. So Mr. Malaro, is there anyone you are ready on?
We're ready on this Rembert, Judge, and we are now ready on Mr. Evans.
All right, so let's take Miss Rembert. Miss Adams, can you just like call the jail and let it ring until they answer for you?
Oh.
I just need Matthew Sinclair, so I got email over. Just remember, hold on a minute. Oh, I have ink everywhere. I don't know how. Okay, so move that microphone. Yeah, you did that. All right. So I have, and I don't know that it's related to this case, but Mr. McCready, I have a victim impact statement, and it doesn't have any names, and obviously the defendant's a male.
Right, so this is, from.
It's not signed. I don't know who it's.
It's from Zared Evans.
Okay, it's on Zared Evans. Okay, thank you. All right, so this is in the matter of the people of the state of Michigan versus Malika Rembert. We have one file 24-21966FH. I have Dave McCready appearing on behalf of the people just because he's here. And I have Sam Malaro appearing on behalf of Ms. Rembert, who is also present in the courtroom. This is a date time set for sentencing in this matter. Mr. Malaro, you received a copy of the pre-sentence report, correct?
Yes, I have your.
All right, Ms. Rembert, you are Malika Rembert, right?
Yes.
Okay, have you had an opportunity to read and review the pre-sentence report?
Yes.
All right, and have you had an opportunity to discuss that with Mr. Malaro?
Yes.
Are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes.
All right, Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence
No,
report?
Your Honor.
Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
That's my knowledge.
The probation department has computed the minimum sentencing guidelines to be 0 to 9 months. Do you agree with that computation?
I have no objection to it.
All right. Before the court passes sentence, Mr. McCready, I know you're not here on this case, but I presume you don't wish to make a statement on this case.
That's correct.
All right, but you're here, so I'm gonna call your name. But Mr. Malaro, is there anything you'd like to say on behalf of Ms. Rembert?
I would, Judge. First, I talked to Ms. Walsh yesterday. There's some kind of, in the pre-sentence report reflects it that there's, perhaps she was screened for recovery court. You know if that happened? Ms. Rembert believes she was. Ms. Walsh does not believe she was.
She has not been, they haven't had their meeting yet to decide.
So I was supposed to have, she probably would have been screened yesterday, except recovery court was canceled because I was supposed to have a trial. And so she would probably be screened at our next meeting if we want to adjourn the sentencing. Yes. I don't know. I really don't.
So she's kind of on the fence about it, Judge. She's already been to rehab on this case while this case was pending. She's done very well. I don't necessarily know that she needs recovery court. I'm not saying she doesn't. I just don't know that she does. She's been pretty reliable in staying in contact with me. I think she stayed out of trouble. Her statement, you know, I think she was in a bad point in her life when this occurred, and so I think I don't know, is it possible she could go into recovery court later while she's on probation?
So, a lot of times people, if they violate or have a relapse, will go into recovery court at a later date. Doesn't have to be at the initial sentencing.
Okay, so I think perhaps we could go forward today to if something she needs a little later, we could perhaps address it then.
Okay, so, you know, Miss Walsh.
I mean, she did express that she wanted it. I know she may not know, but I mean, it wouldn't hurt for her to talk to someone that can explain all of it and adjourn this if that's.
I'm fine. Are you working right now?
No.
Okay, why don't we do this? Miss Adams, when is my next recovery court?
28th.
Next Thursday, yeah.
Okay, so why don't we adjourn this 2 weeks? And then we'll have you screened and give you a chance to talk to somebody. Because recovery court isn't just for people who are actively using, it's also for people with addiction issues. And it does provide a large swath of services, you know, housing and employment help and, you know, a number of things to just make sure that you're stable so you don't have a relapse. So Ms. Adams, can I get a sentencing date after that?
Yep, Judge, we could do September 5th at 8:15.
So I'm gonna, do you have children?
Yes.
Where do they go? Are they in Adrian schools?
No, they live in Detroit with their dad.
Okay, all right. So what day? September 5 at 8:15?
Yes.
All right, and Miss Adams, could I get a notice of hearing for her? All right, so we're gonna get you a notice of hearing. And then, and you live here locally though, right?
Yes.
All right, and then I am going to have you, you have her contact information. So, all right, make sure your voicemail on your phone is set up, okay? And make sure it's not like full, because I call people all the time, their mailbox is full, whatever. Because you're gonna get a call from a number of different people from CMH and from the courts to set up a time to meet with you and talk to you. And you need to make sure you return those calls, okay? So one of them might say unknown, it might say state of Michigan, it might say Lenawee County, whatever it is. If you don't take the call, make sure you check your voicemail and call them back, okay? And Miss Walsh has your phone number and she'll make sure that it gets to the right people, okay? All right, so you go have a seat and we're gonna get you a notice of hearing, okay?
Okay.
All right,
Thank you.
you're welcome. All right. There we got your notice right here. You take some files. If you want. You can find them later. So, any luck with the jail?
No.
Trying to get a hold of my mother. She doesn't take my calls either.
Chad Casey.
Hi, this is Anna Marie Anzalone. How are you?
I'm good. How are you?
I am good. So we are ready for Matthew Sinclair.
Matthew Sinclair.
Yes, sir.
All right, I'll get him in there.
All right, thank you.
All right.
Bye. Mr. Malaro, I have Goncalves in my waiting room.
Oh, is he on Zoom?
Uh-huh.
I tried reaching him yesterday, I couldn't get
So
him.
you're gonna need to talk to him.
Yeah.
So let's do your other ones first.
Sure.
I'm just gonna let him know. All right, Mr. Goncalves, could you unmute your device? This is in the matter of the people of the state of Michigan versus Michael Goncalves, file number 25-22311FH. He's here, but he's not responding, so. All right, so that one. let's do Evans.
Sorry, ma'am.
Oh, it's okay. So, sir, your
I'm so
attorney is
sorry.
gonna
I'm having
need,
a hard time using this.
it's okay, it's okay. So, sir, your attorney is gonna need to speak with you. So I'm gonna do one other case before yours, and then he's gonna go on back and Zoom with you, okay?
All right. Thank you. You are lovely, ma'am.
Okay, thank you. And I'm gonna put you in the waiting room, okay?
Thank you.
All right, thank you. Lovely. Is that what he said?
I love the,
All right, so Mr. Evans?
yes,
And you think we have a victim here
Yes.
as well? Okay. She going to speak or rely on the letter? Okay. Okay, so this is in the matter of Dustin Evans, right?
correct.
This is in the matter of the people of the state of Michigan versus Dustin Lee Evans, file number 25-22262FH. I have Salvatore Milaro appearing on behalf of Mr. Evans, and I have Dave McCready appearing on behalf of the people. I also have a letter dated August 20 of 2025, from pretrial services coordinator Darren Coast, stating that Mr. Evans continues to be monitored with a GPS tether. They have no violations to report. And as far as we're aware, he has done well staying away from the victim in this matter. Now, Mr. Milaro, I do have a letter from the victim, and when we copied it, kind of cut off who it was from. Did you receive a copy of that as well?
Judge, I did not receive a copy, but Mr. McCready let me read his.
Okay, has your client had an opportunity to review it?
He is not.
Okay, do you have your, I'm gonna hand that down so your client can take a look at it real quick. All right, I got the jail, so we'll just skip over to the jail, Miss Underwood. Oh, Miss Underwood's left me too. Mr. Sinclair, Miss Underwood just had to step away from her desk for a moment, so.
Okay. I was gonna hope I could have a breakout with her really quick too, if that would be okay.
Yep, not a problem, not a problem. I just gotta get her back.
Okay, thank you.
Oh, there's Miss Underwood. So in the matter of the people of the state of Michigan versus Matthew Richard Sinclair, we have three files, 24-21920FH, 25-22245FH, and 25-22246FH. I have Brenda Underwood appearing on behalf of Mr. Sinclair. I have Mr. McCready here. I don't know that he's here on that case, but he's here. So I'm going to acknowledge that. Miss Underwood, Mr. Sinclair would like a moment to speak with you. So I'm going to open up a breakout room
Your
to
Honor,
give you an opportunity.
prior
Yes.
to that, can you tell me what the allegation is of the actual violation of probation?
Yeah, hold on. Wait, I gotta get his file. Sinclair. All right, I'm sorry, Miss Adams, you did not get the violation of probation paperwork.
No, I think Frances is looking at her emails and is going to forward it to me because I don't see anything scanned.
Okay, so is it the March 17 of 25 violation or no?
I only saw that one. I didn't see anything on the other two files.
Okay, so Miss Underwood, Miss Clark is looking that up for you right now. So just bear with us for a minute. And when we
Thank
get
you,
that, we will.
Because
get
I
it
have a
to-
recommendation, I have an updated recommendation, and Mr. McCarron provided me with a police report from August 17th. And is that when we're talking about a violation from?
Judge, Miss Clark only had the recommendation as well.
Okay, so we're gonna have to find that, so we're gonna have to call down to Mr. McCarron to get that. Then, correct? Someone?
Or is
Is
this
he
an
on- is he
old
on all-
violation?
Is he on all files, Judge?
Yeah, I've got it for all three files,
Okay.
but I don't see that he pled to, yeah, he pled to larceny, 200 to 1,000. So it looks like he pled to domestic violence, he pled to,
Why? What's the other one?
must have pled to misdemeanors and everything. So we'll get a hold of Mr. McCarron here this morning, so you guys just bear with us. All right, Mr. Malaro, have you now had a chance to review that letter?
Yes, I have. Your Honor.
And have you had a chance to review the letter?
Yes, ma'am.
Okay, good. All right. All right, so, get all organized again. All right, and Mr. Evans, I don't even remember if I asked you now because I've moved on to other things, but you've had a chance to read the pre-sentence report
Yes, sir.
and you've had a chance to discuss it and review it with your attorney.
Yes.
Are you satisfied with Mr. Malaro as your attorney and the advice that he's given you?
Yes, sir.
Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Mr. McCready, do you wish to explain or challenge the accuracy or relevancy of any information?
I do not.
Okay. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect? Mr. McCready?
No.
Mr. Malaro?
That's my knowledge.
The probation officer has computed the minimum sentencing guidelines to be 0 to 6 months. Mr. McCready, do you agree with that
I
calculation?
do.
And Mr. Malaro?
No objection.
Okay. Before the court passes sentence, it's my understanding that we have someone who wishes to speak. So, Mr. McCready?
No, it's zero Evans, right?
So ma'am, step up to the podium and you can pull the microphone down, okay? And make sure you address me, okay? And just look at me and speak loudly. So take a deep breath and when you're ready, you can proceed, okay? What is your name?
My name is Zora Evans, Your Honor.
Thank you. All right, you may proceed.
Your Honor, I'm thankful for the opportunity to express how this whole situation has deeply impacted every part of my life and even my career. As you know, while I was still pregnant, he was arrested for a DUI and had my car impounded. After that, I didn't let him use my vehicle, but he kept asking, and every time I would say no, he treated me with complete disrespect, showing no regard for my emotional well-being. There were multiple incidents where he became intoxicated and verbally aggressive, even in the presence of my mother. I ended up filing a police report after one of those episodes got out of hand. His anger often escalated to yelling, cursing, and slamming doors, frequently in front of my family and heartbreakingly in front of our children. One of the most devastating moments was when I confirmed that he had been using cocaine. So many times when I asked him if there were any reason he would have so many bleeding noses, he would yell at me, telling me I was unbelievable for asking things like that, instead of being concerned for his well-being. So many times he dismissed me and made me feel like I was crazy and dramatic. And then I was later informed by command that I had tested positive for cocaine, a substance I did not knowingly ingest. His actions jeopardized my career and left me feeling violated, confused, and scared. Every time he repeatedly crossed boundaries, calling and messaging me nonstop, breaking into my home and threatening to take our son, I felt less and less safe. He even used the ashes of our miscarried child as leverage, saying he had taken them the day he left, trying to manipulate me into letting him come to the house to return them, but refusing to give them to a family member to have them brought to me. It's difficult to put the emotional and mental pain of this into words. He went so far as to email my mother multiple times, trying to manipulate her and make her feel guilty for protecting myself, saying I was wrong and I was hurting the children. His brother even took the time to reach out and tell me that I'm going to rot in hell for what I am doing to his brother, further isolating and intimidating me. Because of all of this, I have had to start therapy and am now on medication for depression and vivid nightmares. I live in a state of hypervigilance. I can't go to the grocery store without having to scan the parking lot for fear that his car might be there. And every minute I'm inside the store feels like hours, and all I can think is when I turn the corner, he's going to be there. I had to install security cameras around my home just to feel safe and some sense of safety. On top of this emotional turmoil, I've had to navigate work investigations directly tied to his behavior, all while grieving the loss of our child and trying to maintain stability for myself and my children. Your Honor, I respectfully ask that the no contact order remain in place for the entirety of this duration. And I also ask that the remains of our child be returned to me so I may grieve and honor that loss of dignity and peace. And this is not about anger or revenge. This is just about safety and the ability to move forward in life without fear. Thank you.
Thank you very much. Mr. McCready, anything you'd like to say on behalf of the people?
Yes, very briefly. So we agreed to a plea to aggravated stalking here. One of the reasons was that it allowed us to have 5 years probation. And we've agreed to 1 year in jail suspended. And the primary reason for that is so that the defendant has no contact with Ms. Evans. We need something held over his head, and I would just want the court and the defendant on notice that if there is any contact, directly or indirectly, we'll be back here in a heartbeat asking for a jail sentence. I understand that a child in common, I understand they were married, I understand their emotional involvements, but it's been her choice and she's entitled to make. She doesn't want any contact with him from here on out, and she's done everything she's supposed to do in terms of getting a PPO, letting the court know when he's violated it, up to the point of then when he committed this offense, breaking into her home in the middle of the night while she's away on duty, active military duty. So I just want to be on the record and clear that there's to be no contact as the court is going to sentence him. So thank you.
Thank you. Mr. Malaro, anything you'd like to say on behalf of your client?
Yes, Judge. I think the underlying tone here is substance abuse. I think that's clearly a factor here. And Mr. Evans was the one that got involved in it. And I think underneath that was, as Ms. Evans alluded to, is the loss of a child, and people grieve differently. And a lot of people turn to substance abuse to mask that pain. Mr. Evans, because that I think is slowly realizing not only the damage that has caused, they didn't deal with this grief in a more appropriate manner, not only to himself, but to others, including someone at some point in time. These two people loved each other. It's evolved into where we are now. Mr. Evans has managed to, as the court has alluded to, honor the terms of his bond by staying away from this Evans. They have a child. I believe they have a child together. So that's going to have to be resolved in the domestic relations. case and all the things that go along with that. And as the court knows, those are always very emotional components to it. Mr. Evans understands very clearly that he is on a tight leash here. Any violation is going to get him a year in jail. Now, he has a very good employment, and I'm sure he does not want to have that one stable part of his life to get flushed down the drain. We did reach this agreement, and it's clear that Ms. Evans has suffered from his actions. He will have to spend a considerable part of his life trying to make amends for that. I know that he gets confused about his actions with respect to his desire and love to be with his children. Hopefully he can see that how he treats the mother of his children is a direct reflection as his role as a parent to those children. I think that's the point of Veterans Court here, Judge. It will help him come to that realization to be a better person, a better father to his children, regardless of his relationship with his children's mother. The only matter we would ask the court to permit with respect to a term of probation is he has children from a prior marriage that live in Louisiana, and he has a parenting plan with them. And I'd ask the court to allow him to travel out of state for the purposes of that. So with that said, Judge, I'd ask the court to follow the recommendation as submitted. Thank you.
Mr. McCready, for purposes of parenting time with his other children, the people have no objection to allowing travel for parenting time purposes to Louisiana.
As long as he is in compliance with the terms of his probation here, that's fine.
Okay, thank you. So, Mr. Evans, is there anything you'd like to say on your own behalf? And you're going to need to make sure you speak loudly because we do record these proceedings.
I didn't mean for any of this to happen, but I miss my family, I miss my kids, I miss my wife. When I went home, I just wanted to see my kids, and I just laid in bed with them. And this is the last time I even heard her voice, was at night. And it was the last time I was happy. I came to talk to him, see him. I never meant to hurt anybody. That was my best friend. And but now I've been moved from my home. I haven't seen my children, and I love her at the same time, all at once. I go to counseling. It's helping, but it's. I didn't mean to hurt her. I miss my kids. I'm sorry. Anything that I've done upset her.
Judge, I might add, Mr. Evans has engaged with a family law lawyer I've spoken to, so I think some of the issues that Ms. Evans has requested can be dealt with in family law setting.
Okay. So I'm looking, we have a PPO show cause that has been adjourned over with this. I'm looking because I can't remember if anything was filed to end the PPO. And I don't think it was, but the bond conditions do remain in place, and the PPO actually expires on today. So the PPO expires today, and I'm not seeing where it was extended. But do you understand that a PPO violation carries 93 days in jail, right?
Yes.
This offense you're gonna be on probation for carries prison.
Yes, ma'am.
So it's far more effective than the PPO. Do you understand
I
that?
understand.
And the pre-sentence report at the time it was done said there was no active personal protection, or there was, but it expires today. So I don't know. Oh, Mr. Jones, just so you know that. Anything else?
Nothing.
Mr. McCready?
Nothing, guys.
So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. This case will be transferred at the conclusion of today's case to Judge Olsaver for purposes of the Veterans Court Program. You will be placed on probation for a period of 5 years. There is a 1-year jail term that is being suspended pending any violation of probation. That's not really a good deal for you. They're doing that to hold that over your head, because if you violate, you're immediately going to do a year in jail, and we're still going to have the term of probation.
Yes.
Okay. You are to pay $750 in court costs, $130 crime victim rights fee, $68 in state costs, $60 DNA fee. There is a $30 per month supervision fee and $60 if we have to put another tether in. So I know you're wearing a GPS tether today, correct?
Yes.
And I believe that gets removed as of today
No objection at the cross.
because you're being sentenced, but understand that if there is one violation, we're gonna put that right back on you. And one of my favorite things of the week is when the probation officers go follow people and make sure where they've gone, and they watch you, so they know. Your jail is suspended. You will enter and complete the Veterans Court as part of the sentence. During your term of probation, you're not to violate any criminal laws of any unit of government. You cannot leave the state without consent of the court other than to travel to Louisiana for purposes of parenting time. But you can't go anywhere else.
Yes.
Okay. And you must not use or possess alcoholic beverages or any other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcohol for drinking on site, unless you've been given written permission for employment. But I don't want you working anywhere they serve alcohol. So if you go to Jerry's Pub for dinner, that means you gotta leave Jerry's Pub when the dinner service is gone, because then it's the primary purpose for drinking alcohol. You must comply with the requirements of drug testing. You must take all medication as prescribed. Not if, like, some people like to take extra to get high or whatever, you can't do that. You understand? You must test as required for that, as well as alcohol. Can't use or possess any illegal controlled substances or drug paraphernalia, and that does include marijuana, unless prescribed by a physician, or be with anybody who has them. Must truthfully report to the probation department as required. And did you do the domestic violence program with Sally? Okay, so I am going to order that program, Mr. Coast. Miss Sally Welsh. Whose is this? Is it, or I'm sorry, Mr. Jones.
Yeah,
This is yours, right? Yeah, so we'll order that long-term domestic violence program with Sally Welsh.
Yep.
And then, okay, and then you must submit to search of your person and property, and that includes your car, your phone, your residence, wherever you might be, your computer, without need of a warrant if the field agent has reasonable cause to believe you have items that violate the conditions of your probation. The probation department can enter your residence anytime for purposes of verifying your residence and so forth. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours. So Mr. Evans, you know, I do believe in redemption. I believe you have a host of mental health issues, as well as substance abuse issues. I believe that's something you can do, but it doesn't happen overnight. You may never regain her trust, and that's the price you will pay. Do you understand that? But that doesn't mean you can't become a better person or by dealing with these issues and get back to the important things in your life as well. But understand it's not going to happen overnight. Okay. Now, all right. So we have ashes of a child. Okay. And it is your child as well. So, what I'm going to ask is that those ashes be returned when you report to the probation department. Ma'am, you're gonna need to divide those ashes so that he can have half and you can have half, okay? I don't know how, I have ashes, I got my dad's ashes, I have other ashes, but I believe if you take them somewhere, they would be able to divide them so that he can also have some of the ashes, unless you guys had a plan to bury them. I don't know what the plan was. So.
Yeah, I don't want to mess with it.
Okay, so, all right, can you bring them when you report to the probation department? And then the probation department can notify me, and then we'll notify Mr. McCready, and the victim advocate will contact her to get those returned, okay? There is nothing worse than a loss of a child. My parents lost an infant and it impacted their marriage, their happiness and everything else. So I hope that you're in counseling to deal with that loss as well as these incidents occurred in you as well. All right. So he's going to, when you report to the probation department, you'll bring them in and the probation department will let us know and we'll make sure we facilitate getting it to the victim advocate to return. And then you will obey and comply with any other provisions in your articles of probation. You understand that?
Yes.
You have to get in control of your behavior. That's been the biggest issue here.
Yes.
Okay. Now, you do have a right to appeal this sentence, and my bailiff's going to hand down to your notice of right to appellate review. You're going to sign one copy for our file to acknowledge you received the paperwork. The other copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. And Mr. McCready, the PPO has expired as of today. There have been no further violations. Is it all right if I just dismiss the show cause on that?
Yes, although I may have missed it, but I didn't hear your honor say, enforce the no contact provision of the plea.
Oh, there's a no contact.
It's
Yeah.
direct or indirect for military.
Yeah, and I was like wondering, okay, where do you grocery shop?
Myers, you should be.
Okay, all right. And then, do you ever go to Marshall's, Michael's, Ross? Okay, so, because I don't want you to get in trouble for having contact, and I don't want her, so do you shop anywhere else? Okay, and so if you can just limit in Lenawee County, your grocery shopping at Meyer. And ma'am, that would free you up to shop other places. All right. Obviously out of county, you can go wherever you want, right? So, but all right, we'll add that as a term as well. All right, Mr. Jones, do you want him to report Tuesday morning at what time?
Well, Judge, he's actually going to go to Miss Teskey's caseload, and she's in the office today. I think she'll be expecting him to come over there, so he can just report today. But I was going to say, obviously, the ashes probably wouldn't be taken care of today, so he can just note that for the next report when she gives them.
Okay. All right. So when you're done here, you're going to go out the hallway and step over to the probation department, check in and sit down. All right.
One last thing, Judge. One last thing. So that Louisiana travel, is that a regular occurrence? Was that just a one-time deal, or how is that? I just want to get clarification.
I have a court order. Every spring break, summer, every other holiday.
All right, so you're going to need to get a copy of that order to the probation officer. And so it's a couple times a year for parenting purposes. And if he's doing well on probation, I have no problem with that.
Okay, can we just make sure that's on the judgment so we can have that on the terms, and then there's just no confusion if we get
so Ms. Adams will add that is able to travel to Louisiana for purposes of parenting time.
Thanks, Judge.
All right, so I'm gonna have you step across the hall and then we're all set. Thank you.
Judge, if I may, or just so I have a complete understanding, he's only to shop at Meyer for groceries?
In Lenawee County.
Right, but only Meyer for groceries.
Yep, so because he said that's the only place he goes.
Okay.
So, all right, and I think that won't impede him and that'll ease her mind a little bit too.
Understand.
Okay, all right, very good. So go to the probation department. Thank you. Mr. Malaro, if you could go in my jury room and she'll let you back there and Zoom with Mr. Goncalves, I'll take care of Mr.
Sure, thank you.
Claire, hopefully with Miss Underwood while you're doing that, all right? Miss Adams, were we able to find anything?
Judge, I sent you a chat on that.
Okay, let me see.
I didn't get the chat.
She didn't send the chat to you, Miss Underwood. Okay. All right, I'm gonna step off the bench for a minute. Intact.
Sir, what's your last name? Okay. Okay, gotcha. Okay, yeah, you're usually okay. Welcome.
How you doing?
I'm
You
doing
good?
okay,
Good.
okay.
Yeah.
It's Friday. Right?
Yeah.
Yay.
Yes.
Hello?
It'll be a minute.
The judge is just in a recess. Just hold on, please.
No, I'm sorry. I apologize. I didn't know if this
No,
was
you're-
working.
That's okay. Thank you. She'll be right back.
All right. Mr. Murphy? That's your attorney, right?
All right, can you hear me?
We can hear you, sir.
Okay. Thank you.
So beautiful. Amazing. Yeah, amazing Jane. Oh, she's beautiful. She is beautiful. She's cuddly. Yes. Oh, she's 6 weeks. No, she's 4 months. Yeah. She's beautiful. I love her markings and her color. It's like caramel. Yes. She reminds us of James. I think that's Chasey. She's really oh, Chasey can be very marketable. Amazing. That's she's beautiful. So how are the others? Good. Good. Yes. Good. Oh, she's beautiful. She's so she's so sweet. Did you get friends for lunch? Did you bring lunch today? I did. Do you want some lunch? Let's do it. Yeah. Okay. Whatever you say, whatever sounds good. Whatever. I'm good with anything. What do you think about it? Okay.
Laundry bit. Just separate our shit from our things from their things, and then I'll take our things back downstairs.
Okay. All right, so Miss Underwood, if you are back. So Miss Underwood, with this, he was on district court probation because all of his files were reduced to misdemeanors. And then he was arrested, I believe it was Sunday night, by the police department because he was on site, the victim's home, and then he registered a 0.09 PBT. So he violated the arrest was for violation of bond conditions and consumption of alcohol. So that's why the district court probation department they didn't lodge them, the police did. And so that's why we had the violation of probation, and it's summarized in this. So when I arraigned them, I told them the allegations. And so at this point, I think you've been sent the allegations, correct?
Yes, but there's no warrant for violation of probation.
Well, we don't do warrants for violation of bond, like conditions of probation necessarily, or for like violation of PPOs or bond conditions. So
So it's a contempt.
basically it's treated the same as a contempt, a violation of probation, probably, you know.
Well, it's either a violation of probation or it's a contempt, which is a 90-day misdemeanor.
So no, it's not a contempt. I mean, I'll have Mr. McCarron do the warrant if you want, and that's fine. He can get that done in a couple minutes.
Well, I'm just trying to ascertain what we have, you know, because that's kind of important in terms of the sentence involved.
Well, it's not a contempt, so I'm not limited to 93 days, no. So, but Mr. Sinclair would like to talk to you, and I can get a warrant if you feel it's necessary. That's fine, I can get that. So let me tap you in a, oh wait, don't join that breakout room. I did the wrong one. So I'm gonna close the breakout room. Put you in with Mr. Malaro's client. So hold on. So let me try that again. So Mr. Goncalves and Mr. Malaro join a breakout room. And go ahead and talk. Okay. So, but Mr. Sinclair wants to talk to you. So let me put you guys jail.
Please and thank you, Your Honor.
Yep, you're welcome. And Miss Underwood. Okay. Miss Spain. Yes, Judge. What is your name?
It's Hodges.
Hmm?
It's Hodges.
Okay.
The attorney's Matt Murphy.
Matt Murphy? Oh,
Yes, Your
you were
Honor.
lurking and I didn't even know you were there. Mr. Hodges, you want to come up? He had his video off and I just didn't even notice him. All right, you just stand right at that podium. I'm sorry. So this is in the matter of the people of the state of Michigan versus Antonio Demetrius Hodges, file number, hold on one second. 25-22119FH. This is the date and time set for, I see a plea agreement from July 9, and I see. Sinclair. Hold on, I gotta find your PSI. Okay, so, okay, here we go. This is the date and time set for sentencing in this matter. And Miss Adams, did you email Miss Underwood the police report on Sinclair? Because I do have that. All right, so this is the date and time set for sentencing. Mr. Hodges, did you get a chance to read your Antonio Hodges, right? Okay, you gotta speak up for me, okay? So you can move that mic if you need to. Did you get a chance to read and review the pre-sentence report? All right, are you picking them up, Miss Spade?
Yeah, just a little louder.
Just a little bit louder, you're very soft-spoken. So did you got a chance to read it, and have you had a chance to discuss it with your attorney?
Not yet.
Not yet. So, all right, so I am going to walk him out in the hall, Mr. Murphy, and set him up on Zoom, okay?
Thank you, Your Honor.
So, let's go. So I'm gonna connect you to the Zoom device in the hall, right?
Sherry, get going. Well, you gotta get going. I know. You gotta keep up. That's not usual. Very expensive. Oh, get you through off court officer.
Yeah, Doug's used to. John Blackman always got mad because I disappear all the time and I go over to probation and then he had to hunt me down. Okay, so. All right, let me bring him in. All right, so I'm gonna ask him to unmute. Okay, I'm gonna ask him to start video. All right, so now I'm gonna put you guys in a breakout room. So you're gonna click on join, and when you're done, you can leave it be and just come on into the courtroom. Here we go. All right, Miss Underwood, I didn't mean to ask. There was a report, a police report. Did you get that?
I received that from Mr. McCarron, Your Honor, at my request. Thank you. Your Honor, here's the only thing I have. This was not a bond violation.
No,
He wasn't on bond.
No, it's a probation violation.
But we don't have a show cause or a like paperwork showing that.
Right. He was arrested and lodged, and we have a warrant, a request and warrant now. So that'll be on
a warrant now.
Yeah, we're sending it over to you now. All right, here you go, Miss Adams.
And Your Honor, in terms of possible sentencing in this matter, I believe Mr. Sinclair works. He has older children. He would be willing to do any sort of tether that the court would propose. But he, Your Honor, this was not a situation, I believe, where anyone was in any danger. Would the court consider a sentence with time served and a tether in this matter?
So, okay, so one, yes, because I honestly believe a year in jail with credit for time served will not solve any problems, especially with Mr. Sinclair. But this is not his first violation, and Mr. Sinclair does not seem to be taking this seriously. So we had a prior violation in March where he violated a no contact and was charged with domestic violence and interfering. And then, you know, these cases, bad things happen when Mr. Sinclair consumes alcohol and goes where he's not supposed to go. And so this isn't our first round. You know, the underlying charges were incredibly serious charges, and Mr. Milaro was able to work out a very good plea agreement for him. So here's what I would say, Ms. Underwood, we can do one of two things. We can plead him to the violation today. I'm going to continue his probation and require a GPS tether for a period of time until I feel that, you know, he's doing what he should do. Or if you don't want to plead him today, I can set bond where he's required to wear a GPS tether and report to probation as required and adjourn it out. So whatever you would like to do, Ms. Underwood.
Your Honor, I think I like the second alternative. And Mr. Sinclair, in case you just didn't understand that, that is a huge opportunity for you. Huge.
Correct.
Both
I
to
understand.
keep yourself sober and to keep yourself away from where you shouldn't be.
I understand. Yes. And I would appreciate that very much, Your Honor.
All right. So here's what I'm going to do. I'm going to give you a PR bond on each file. I'm going to require a GPS tether. You just need to stop, Mr. Sinclair, because you're going to end up catching a new charge and going to prison. And
Yeah.
so I
Your
think
Honor,
there's
would
no
this be-
alcohol.
I apologize.
No alcohol if it's not already a bond condition, not to be in contact with victim. These are bond conditions as well as probation terms. Miss Adams, I would like a date out about 45 or 60 days.
And Judge, the GPS tether, is that done by Darren or Mike McCarron?
Whatever, I think Darren, I don't know. I think it would be done by Mike McCarron. Let me ask him.
If it's a bond condition, it's probably Darren.
Yeah,
Okay,
I believe
we'll do-
Darren.
Yeah, we'll do Darren Coast. So we'll let Mr. Coast know. We'll do that. And we'll let Mr. Coast know and he'll, let me see if I can get him to log on. We're 7:15.
Hello, this is Derek.
Hi, Mr. Coast. This is Judge Ann Sloan. I'm on the record with Matthew Sinclair.
Okay.
So I'm going to be releasing him on a PR bond with conditions that it's a violation of probation, but I'm doing bond conditions.
Very good.
So I needed,
GPS tether, any restrictions?
yeah, not to be around the victim, and no alcohol.
Okay, very good.
And he is on probation with Mr. McCarron.
Sounds good. I appreciate it, Judge. Thank you.
Will you talk to him at the jail?
What I'll do is I'll go ahead and do the paperwork. Is he on Zoom right now?
Yes, sir.
I'll zoom in and I'll have a breakout with him real quick, if that's possible.
Okay, thank you.
Thank you. Bye.
I work fast.
And Judge, I'm
Yeah,
looking
we're
at
good.
October 22nd at 8:30.
So I'm going to set this over to October 22nd at 8:30. So you're going to need to report to probation as often as required. And then you're going to also have to follow any direction by Mr. Coast as well. All right.
Yes, I understand, Your Honor. Thank you.
It's strike two. You know that, right?
I'm I'm very well aware. Yeah.
Okay.
I got
All
some
right.
work to do.
Yep. All right. I'm going to let Mr. Coast in, and then I'm going to probably put you in a breakout room with him.
Thank you, Miss Underwood.
Mr. Sinclair, If you do this, this is going to be really good for you.
Thank
Okay?
you.
All right, Mr. Coast, do you want to break out room with Mr.
Yes, please.
Sinclair?
Thank you.
All right, so let me find Mr. Coast. Oh, there it is. Okay, go ahead and join that breakout room.
Gotcha.
Thank you, Your Honor. I believe that concludes my docket. Have a good weekend, everyone.
You too, thank you. All right, so I am back, Mr. Malaro with Mr. Goncalves. So let's get him back. I've been chaos this morning and I don't know why. Okay, so this is, Mr. Goncalves. Did I pronounce your last name right? Go ahead and unmute your device and start your video, please. All right, Mr. Murphy.
Yes, Your Honor.
Why don't you come back up? Let me find your file. All right, so we're gonna skip over to Mr. Hodges. So Mr. Hodges, and now, okay. All right, Mr. Goncalves, hold on just a minute. I've skipped over to another one, so you just stay right there. All right, so Mr. Hodges, have you had a chance to read and review your pre-sentence report?
Yes, ma'am.
All right, and you've had ample time to discuss it with your attorney?
Yes, ma'am.
Are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, ma'am.
Mr. Murphy, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
Your Honor, I apologize. I didn't write a memorandum in regards to this, but I would object to the offense variables that are scored. I don't know if you want me to go over that now or
Then
that.
I'm gonna, all right, so Mr. Hodges, you have a seat right there. So let me get Mr. Goncalves done before we do all that. All right, and Mr. Malaro said as senior trial defender, vice president, whatever he has authority over you, so I'm gonna skip to him now. So, all right, so, Mr. Goncalves, did I pronounce your name right?
Yes, ma'am. Can you hear me now?
Yes, yes. Okay, thank you. I pronounced your name right though?
Yes, ma'am.
Okay, so Mr. Malaro, and you and Mr. Goncalves have had a chance to discuss the pre-sentence report?
Yes, sir.
All right, Mr. Goncalves, you've had a chance to speak to your attorney?
Yes, I have.
Are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, ma'am. I understand everything and I'm satisfied.
Oh, excellent. Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
I do, yes.
You do?
Yes,
Oh, okay,
very minor.
okay.
So, Your Honor, his address is 1-2.
Not, can you just give us that? We're live.
Oh.
You can just give it to me in writing.
Okay.
We'll update your address. Okay.
He is also employed at the Clayton Lumberyard.
Okay, Clinton.
I can tell you that though.
Yep. So he's employed at the Clinton
Clayton.
Lumberyard?
Clayton.
Clayton, excellent.
Booming metropolis.
He's what?
The booming metropolis of Clayton.
Yeah, isn't it like the Four Corners or whatever? Yeah.
He has 2 children. That would be the update.
Okay, excellent. I've made those notes. All right, and I show does he have any prior record?
According to the pre-sentence report, he does not.
Mr. Goncalves, do you have any prior misdemeanors or felonies?
No, ma'am.
Okay, good, good. All right. So, sir, just so you know, once you complete probation, you'll be able to file for an expungement. How old are you?
I am 27 years old.
Okay. You'll be able, once you complete probation after a period of years, to get this taken off your record, okay?
All right.
Okay, good. All right. So, Mr. Malaro, is there anything you'd like to say on his behalf?
I would, Judge. Mr. Goncalves presents himself as a very amiable, decent guy. I think there was a co-defendant in this case. I think he just got caught up in making a bad decision. He's 20, in his late 20s. He's no record. He's fully intent on making this right. I've explained to him that if he can get everything completed after 6 months, he can even ask the court to get off probation early. I would ask the court to file the recommendation and be as lenient as possible on finding the
Okay. Mr. Goncalves, is there anything you'd like to say on your own behalf?
No, ma'am. He seems to
Okay.
have got it right on.
Okay. So in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines which don't apply, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. So, Mr. Goncalves, the restitution in this matter is $1,400. So, obviously, it's more important that restitution be provided to the court, to victims in this case. So, what I'm going to do is I'm going to place you on probation for 12 months. I'm going to order $75 crime victim rights fee, $50 in state costs. There's $100 law enforcement fee, $30 per month supervision fee for probation. And then I'm going to order restitution in the amount of $1,400. So, like Mr. Malaro said, if you pay all of that off and complete the terms of your probation, you can be released after 6 months. Do you understand that?
Yes, ma'am, I do.
Okay, good. Now, you are going to have to report to the probation department and district court. Do you remember going there to talk to Mr. McCarron? Oh, wait. No, you've never met with them. So the reason the report was wrong is he had not met with the probation department. So what are your work hours, Mr. Goncalves?
I normally work 6 in the morning till 3 in the afternoon.
Okay, so I don't want you to miss work.
One of them days, I would just take the morning off and go back to work afternoon.
Okay, so Mr. Goncalves, I need you to report. Do you have something to write with?
No, ma'am, I do not. Can you give me 20 seconds?
Okay. That's a long time, 20 seconds.
Depends on how far you gotta go.
Yeah.
All right, I'm sorry, ma'am. I did it.
Okay, didn't even take 20 seconds. So, all right. So today is August 22nd. So August 28th, 8/28, I need you to report to the first floor district court probation department, and you can go right at 8 a.m. if you want to get it done. And they're going to review your terms of probation and have you sign it and get your information. So they'll probably require you to report like once a month. I'm not going to add any alcohol terms. I'm not going to add anything else other than report as required and pay your fines and costs. Okay.
All right.
And because you have 2 children and you work I'm not adding court costs or anything because the restitution's pretty high and I want you to pay that, okay?
Thank you, thank you.
But you have to show up next Thursday at 8 o'clock or I'll have to issue a warrant. I know you didn't appear for the other one, but I really need you to do this one, okay? So next Thursday,
yes, ma'am.
8 o'clock, district court probation, okay? All right, and I wish you the best of luck, okay?
Judge, for the record, for some reason, the co-defendant didn't pay any restitution.
And he's already completed probation.
Right, and I informed Mr. Goncalves that whatever he pays, he can go to small claims and recoup half of whatever he pays. Further, Judge, with the reporting, he informed me, he called the clerk's office about what he had to do. Obviously, the clerk's office is not probation. And they informed him that it's nobody's fault, but they informed him his next court date was today, and so that's why he didn't attend. He didn't go to probation. I don't think he fully understood.
Okay. And then, sir,
Yes, I did not.
that's okay. And then you're not to be on the premises of Advanced Auto Parts, okay? You can't go there.
Okay, okay.
All right. Okay, good luck to you. Thank you. We're gonna mail to you your notice of right to appellate review at the address Mr. Malaro is gonna give Becky a copy of. And so when you get it, you're gonna get an envelope and it's gonna have a self-addressed stamped envelope to me, and then 3 copies of your notice of right to appellate review. And 1 copy will be highlighted and flagged for you to initial and date. I want you to initial it and date it, pop it back in that self-addressed envelope and put it in a mailbox or a drop box. And then the other 2 are for you. And if you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days, okay?
Okay, and I did have one more question for you, ma'am.
Okay.
Just to be clear, it was Thursday at 8 o'clock.
Yep.
Okay, and it's on the 28th.
Yes, sir.
All right, and just sign an initial, the one.
Yep.
And
Yep, when you
send
get
it back.
the paperwork, yep, initial it and date it and put it right back in the self-addressed stamped envelope we gave you.
All right, sounds easy enough.
All right, thank you.
All right, and I apologize again for missing the PO. I had no idea.
It's okay, not a problem. You showed up today. That's the most important thing. Thank you.
All right, thank you, ma'am. I can exit out of
Bye-bye.
this?
Yep, you can exit out.
Okay, you have a nice day.
You too. Thank you.
Thank you, Judge.
Thank you. All right, so, how is it the end of August already? Okay. All right, we are back to you. Last but not least. So, let me get my guideline book, Mr. Murphy. Let me get back to the guidelines. So which one you're objecting to OV what?
The scoring of OV9 as a
Hold on, let me
10.
get there. Let me get to OV9. So OV9 is number of victims. OV9 is scored at 10 points. And so, let me get back, hold on. Okay, all right, so go ahead.
Your Honor, I'd argue Mr. Hodges, he pled guilty to going dead weight, and that's what's clear from the narrative was that he refused to act in any way. I would argue that he didn't do anything that placed victims, any number of victims, in risk of physical injury or death. That would be inappropriately scored. Again, he didn't punch, strike, or do anything that would place anyone in physical injury. So I'd argue against the scoring of those. And that was all, Your Honor.
Okay, so description of offense narrative. Police came into contact with him on the Kiwanis Trail. I swear nothing good happens on that trail. But so they said they were going to take him under arrest. Officer placed the defendant under arrest. he began to resist by not walking cooperatively and then became dead weight and dropped to the ground. He planted his feet, pushed back and dropped to the ground again. Okay. Okay. So number of victims, let me go back through, and they scored it at 10. 10 would be 2 to 9 victims were placed in danger of physical injury or death. And okay, so in this case, he pled to 1 count of R&O, and he was charged with only 1 count of resisting and obstructing, which listed Colin Castleberry as the police officer. And I do have your case. I'm assuming that the second one would be for the second officer that was on site. And I just saw it. Hold on, I just saw a case. So in this case, there was not assault of the police officers by the defendant. Failing to comply doesn't rise to the level of that. And 10 is scored for 2 to 9. And in this case, there was no charge of conduct for the other police officer. So I will, in this case, for only 9 at 0. Let me see, was there another one, Mr. Murphy?
That's all, Your Honor, which doesn't ultimately change his scoring. I just wanted to argue that for the fun of it, I guess.
Oh, it doesn't change the sentencing guideline range?
It doesn't. I mean, obviously it drops the OVs down by 10, but that still puts him at the 25 split for 13. So.
Okay. Okay. All right. Anything else with the guidelines?
Nothing further, Your Honor, with the guidelines.
All right. Before the court passes sentence, is there anything you'd like to say on behalf of Mr. Hodges?
Your Honor, obviously the plea agreement, I believe, is appropriate in this matter, which is why I pushed for that. Mr. Hodges, I don't believe incarceration is necessary or appropriate. The cost of it wouldn't be appropriate at this time. He's doing well. I would ask that the court sentence him to, a non-custodial sentence of probation. I don't think it's necessary for 3 years, but obviously we will know if he completes everything appropriately and as fast as possible, he can get off within a year and a half or after he completes half his probation. I would ask the court to maybe consider less than 3 years, but either way, he'll perform well on probation, I believe. And I don't believe you'll see him in front of the court again unless it's for ultimately failing to pay off all of his fines and costs, because that may be an issue over time. But again, I know he's going to make his good faith effort to do everything he needs to. So I'd ask the court again to, follow the plea agreement and to sentence Mr. Hodges to a period of probation.
Okay, Mr. Hodges. So, do you currently have housing?
Yes, ma'am.
Okay, good. Are you working? Where are you working at?
Yes.
Okay, awesome. Okay, working full-time?
Yes.
Excellent. All right, is there anything you'd like to say on your own behalf?
Thank God. No, just grateful to just, just be able to get this over with and move on with my life and be a productive citizen.
Okay. All right, so Mr. Hodges, yeah, it looks like
Rough patch in my life, and that's time to straighten up.
I understand, but you haven't gotten in trouble for a while, so. All right, so Mr. Hodges, first, thank you for your patience. You've been sitting here all morning and it's kind of been weirdly chaotic this morning. It's not usually that bad. So it's sentence of the, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, along with what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, potential for affirmation, protection of society. So, trying to figure out. You're not on parole anymore, right? Okay, good. All right, it's sent to the court, it'll be placed on, do you have children? Are they minors?
Yes.
Okay. Sent to the court, you'll be placed on probation for a period of 18 months. During that term of probation, was alcohol involved with this? No. All right, I'm gonna strike one. You're not to use any illegal controlled substances. You must complete an assessment if necessary regarding substance abuse, mental health, domestic violence programming if recommended. Probably not because it's not part of this offense. Not to use any object as a weapon, can't possess any weapon. They can enter your house for purposes of probation supervision, just to verify you live there. You must submit to a search of your person and property, including or not limited, but not limited to your vehicle, your residence, your computer, whatever you have, without need of a warrant if they have reasonable cause to believe you violated the terms of your probation. I'm going to order a crime victim assessment fee in the amount of $130. There's a $30 per month supervision fee, $60 if we have to put a tether on you. I'm going to order $500 in court costs, $68 in state costs. Because I know you're making minimum wage, you have children, so I've reduced that a little bit. And you'll have the 18 months to pay it off. Ms. Holly, do you do the monthly amount?
I can figure that out for them.
Yeah, so we'll give you a monthly amount you have to pay so that it's paid off by the 18 months. Obviously, if you do well on probation and you pay it off sooner than that, at the halfway point, the probation department can release you from probation, all right? Now, you do have the right to appeal this sentence, so my bailiff is going to hand down to you notice of right to appellate review. She's going to have the initial and date, one copy for your records, the other copy are for our records, and if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days.
You should pay $40 a month.
Okay, so it'll be $40 a month. If you want to pay twice that, you'll get off sooner, all right? All right, good luck to you.
Thank you, Your Honor. Thank you, Mr.
Thank you.
Hodges. You have a good day, okay?
All right, thank you.
All right, and just follow Miss Holly over and she'll tell you what you need to do. I received back a signed copy of the notice of right to appellate review. Mr. Murphy, we have Mr. Daniels at 11, right?
Yes, Your Honor. I'll be back at 11 unless you want me to come back sooner.
Who's your prosecutor?
Isaac.
All right.
I'll log off now and come back at 11 if you want.
Okay, thank you.
Thank you, Your Honor.
All right, Mr. Noe, I apologize. Thank you for your patience.
No, I looked at your docket. You had quite the docket this morning, didn't you?
Well, it wasn't as bad. It was just like a lot of chaos for some reason.
Yeah, it looked intense. But yeah, you should have Mr. White logged in. And my
Yep, they're
client.
all. I'm starving now. For some reason, I want breakfast pizza from the corners. Oh. All right. So Aaron Neiman and Matt Kester, I apologize. Oh,
You should have Mr. Heisha too. Is he not in your waiting room?
oh, yep.
If you let him in, please. All right, let's get that around so the judge can see you. Yep, whatever's. You can move that around. So there you go.
All right, we're just waiting for Mr. Hersha. They probably gave up on me because we were going so long over.